All right, so good morning. And again, welcome everyone to our Extended Foster Care Practice and Legislative Updates webinar. This is our second time offering this webinar. We created it and offered it for the first time last year, which was the 10-year anniversary of the Extended Foster Care Program in California. And we got a lot of good feedback that people really appreciated the information and requests to make it an annual thing. So we're really excited to have so many of you joining us today for our second webinar. My name is Emma Black, and I'm a academic coordinator with the Northern Academy. I oversee kind of everything child and family teaming, child adolescent needs and strengths, and everything family reunification post-permanency through extended foster care for training and supports. I'm super excited to be here in partnership today with David Myers, and I will allow him to introduce himself.
Good morning, everyone. It's so nice to see so many of you that I know and some of you that I haven't seen in way too long, and some of you that I saw recently in Costco. Um, so, I am an attorney. I've been doing child welfare for about 30 years. I've been fortunate to have represented everyone involved, starting my career as county counsel, parents, children's, tribes, and the judicial branch when I worked for judicial council. So I was involved with the original AB 12 implementation. I was in charge of training for the judicial branch at that time. And currently I represent parents and children. And so I am very happy to see all of you, and I look forward to sharing all the content today.
Wonderful, thank you. And we are again joined this year by Simone Turek-Lee. You can introduce yourself.
Thanks, Emma. Good morning, everyone. Happy Thursday. I work for John Burton Advocates for Youth. I'm our Director of Housing and Health, and we are a legislative advocacy organization that also works heavily on implementation. So I know we've worked with a lot of you on implementing certain budget investments or bills that are rolling out in your county. So I'm happy to be here and talk about some of the things that we've worked on and some of the things that we haven't worked on that are just good to know about.
Wonderful, thank you. And as I mentioned earlier, Simone's partner, Sarah Potter, will be joining us shortly to bring in some really helpful information talking about new changes and opportunities in education. So we'll welcome Sarah when she joins us. So we really want to make this an interactive webinar. So we encourage you to use those icons and emojis throughout our time today. Feel free to raise your hand to ask a question or utilize the chat to ask a question. We would love it if you want to have your cameras on so we can see your faces, see how all of this is landing. So all of you are here today because you have some connection to working with foster youth, non-minor dependents, working in this program that we call extended foster care. So sometimes it's important to just travel back in time and talk about why extended foster care. You know, why did California do this thing where we said we're going to have a foster care program that doesn't end at 18, but branches until the age of 21 for our system-involved youth. In October of 2008, the federal government enacted the Fostering Connections to Success and Increasing Adoptions Act, which really allowed the opportunity to use federal funding to extend foster care up until the age of 21. California enacted that legislation through a bill called AB 12, which passed in 2010 and took effect in 2012. AB 12 was really the output of a ton of advocacy work on behalf of foster youth with lived experience navigating foster care in California. The California Youth Connection were huge champions for this bill and the opportunity to expand foster care. And California has really paved the way for almost every state to offer some kind of extension of foster care beyond the age of 18 for qualifying youth. So we're going to be talking about lots and lots of things today. We're going to cover some of the key changes that have occurred in recent years. So we're not going to cover every single all-county letter and practice that has occurred, but we're going to try to focus in on some of the key things 2019 to current. We're going to talk about eligibility issues and opportunities, re-entry, immigration, procedural issues, sexual and reproductive health, expected parent protection services and benefits. We're going to do some discussion around housing issues and opportunities. There's some new expansions to social worker obligations regarding housing. We're going to talk about different types of placements, housing resources for youth transitioning out of care. Again, we have some great new content coming in this year to talk about educational issues and opportunities. We're going to talk about economic security, the expansion of the Foster Youth Bill of Rights, court report reminders, and we will make sure we leave time for questions. So again, we worked hard to put together this, I think, really helpful resource document. So please reference that throughout our time today. You don't need to take notes on everything that is covered, but within this resource document, there's a real short summary of what the key practice change was. And then there's a link to the policy letter, the state statute, the updated judicial form, and then in that right-hand column, it talks about when did that change become effective or when was the guidance from the state issued. In addition to that, there are some really wonderful practice guides, mostly created by the organization that Simone works for, the John Burton Advocates for Youth. So get yourselves familiar with that resource document, then use it throughout our time together today.
We're going to talk about Assembly Bill 640. So this, just to give, I need to give a little context here before we dive into this one. So as people may know on the call, whether a youth's foster care placement and the costs associated with it are covered partially with federal funding is really determined by the income level of the home from which they were removed. So it's really tied, and it's hard to believe, but it's tied to a very ancient income threshold. So it's, believe it or not, it's the federal poverty limits with the now defunct AFDC, welfare program from the 90s. So the 1996 federal poverty limits are what determines a youth's whether they're federally eligible or not. And being in California, we already tend to earn more than everyone else in the country. I mean, we are a much higher cost of living state. So for us, the federal poverty level is quite low. So you have to think a lot of young people, even if they're coming from a home that's considered low income here in California, it's not necessarily going to qualify to be below a 1996 federal poverty limit. So what this bill is really about is about trying to access as much federal funding as possible, understanding that when youth are becoming young adults, there should be an opportunity to reassess their eligibility based on their own income level. So what this really does is, benefits, I will say, the state and the county in terms of budget, and allows us to really maximize federal contributions to foster care. So AB 640 is really about, redetermining eligibility once youth reach 18. So this means we're tying their foster care eligibility to their own income. And, some are working, some are not, but they don't tend to be, at the age of 18 earning a ton of money, right? So generally youth qualify when you reassess for eligibility. So AB 640 permits a new determination of Title IV eligibility for non-federally eligible youth when they turn 18 in order to gain access to federal funds to support the youth's placement. So it requires a court-ordered break in dependency, a very brief one, with immediate resumption of jurisdiction. And I think it's important to also know that if the youth is already federally eligible at the time that they turn 18, you don't need to do a new federal eligibility redetermination. Just leave as is. But for youth who are not covered federally, this would benefit everyone to make this redetermination. So this is something that is, I think, rolling out sort of slowly. I think some counties are adopting it and maybe some have not yet, but it's something to look into in your county and see what the status is currently and whether this is in practice in your county.
All right, and good morning. Just a couple things that are foundational and true with everything. First of all, this is your webinar, and if you are here please take a moment, pause, think about why you came onto this webinar and what it is that you need to know and get out of this webinar. Whether it's putting a Q&A in now or at the end, please make sure that you leave this webinar getting your questions answered and getting what you need out of this. The folks around me are really wonderful at answering questions. And if there's something we don't know, we promise that we will find out and get back to you. Couple of things, though, as we get into the legal. Number one, remember, dependency is open book. Child welfare is open book. There are people around you that can help you, and the answers are there. You don't have to have any of this memorized. And all the details we're throwing at you today, when an issue pops into your head, just remember, oh yeah, I remember the webinar. You're going to go back, take a look, and get your questions answered. Starting right here with filing a 388F petition, let's remember your best resource is your county council. You guys pay lawyers to help you with these things. And looking at most of your counties, I think you have at least one or two excellent county council in your county who'd be more than happy to help assist with that. And don't forget that they are there for you. When looking at these petitions, make sure, and by the way, there is an ACL that specifically deals with this. It's 22-72. So if you are dealing with this, don't forget 2272 is there for you. Do not file the petitions if they're categorically ineligible. And then when you have a tribal member, make sure you work with the tribe. Make sure you reach out with the tribe and coordinate to make sure that filing this petition is not going to cost them more than they're going to gain. And then when filing the petition, here are some of the things you need to have with you, and hopefully your lawyer will help you with this too. The JB 469. The petition actually can and should be granted without a hearing. Just check with Minors Council, who will become the NMD Council, to make sure that they're on board with that. And if they're not, get them. They should never be in a situation where they'd be opposed to this, unless it has to do with the tribal membership and losing more than they're gaining. That would be something different. But really, you should not be going to court for these. They should be granted because it's automatic. The law is very clear. And then once the petition is granted, a new EFC agreement, you actually do not need a placement change form unless there is an actual change in placement. We are ready for the next slide, Emma. All right, re-entry for adopted NMD or NMD in guardianship. Yeah, we're glad we're talking about this. Again, the ACL is 19-31, so some of you should have had some experience with this over the last couple of years. The law that recently passed is AB 2337, and AB 787 expanded the eligibility to include youth whose adoptive parents or legal guardians died between 18 and 21, with the youth being 18 and 21. So it's what's been happening since AB 12 was implemented was we've had all these case scenarios where the original legislation didn't contemplate, and we really want these youth to be included. So this is another situation where that has come up over the years. And so now the law has been expanded because we really want to capture this population as well. And so one thing to watch for is whether the adoptive parent or legal guardian is receiving benefits. This isn't really all that different from the eligibility that exists now in this way, but because they're non-minor dependents, it's another sort of mindset transfer when you're dealing with adults as opposed to foster children. And of course, youth under 21 who receive SSI can seek reentry just like those youth who receive KingGAP or AAP payments. Valerie has a question regarding reentry. Emma, I'm going to defer to you. Do you want to take it now, have her pop on? Do you want to ask her to put it in the chat? What should we do with Valerie's question?
Yeah, I think this is a hot topic. And so I would love to see if we could field a couple of these questions. And I am not an attorney, so I will say that you might be our better answer of the questions. But there was a question, what is the age limit on the one for adopted kids? Sounds like Valerie has a question for reentry of guardianship youth. And then another question if they can receive SSI and EFC at the same time.
All right, so Simone, I'm definitely going to ask you to weigh in as well. And In terms of the age limit, it's the same. It's 18 to 21. So that doesn't change. They have to be eligible to be a non-minor dependent in order to receive come back and receive these benefits. Can they receive SSI and EFC at the same time? Yes, because SSI is their money. And although whether they actually receive the SSI or not is a completely different subject, but the answer is yes. If you're having a particular youth who's having trouble accessing the SSI, and if you're having an eligibility worker told, if the eligibility worker says no, they can't do this, go to your county council immediately and the minor's attorney and deal with this on a case-by-case basis. The answer is yes, they can receive this money at the same time, but somebody's going to tell you they can't. And so you're going to have to sort of push through and dig deep to get the youth all the benefits that they're entitled to. If they were adopted at like 3, can they re-enter? Again, it depends on what has happened between their 18th and 21st birthday. So if they're adopted and then their adoptive parents pass away. Well, Simone, actually, do you know the answer to that question?
Sorry, I was going to comment on the SSI piece, and I missed the very last thing you said.
Go ahead and comment on the SSI piece, and I'm going to look up this other question.
Okay. The SSI piece is like, yes, they can absolutely seek reentry, but I think one thing that's good to know is that the funding, the dollars, like they actually have to, so SSI and extended foster care dollars, they're offset dollar for dollar. So you can't receive this amount of, extended foster care funding and this amount of SSI. Like it has to be, they offset one another. So what you have to do in order to maintain SSI eligibility when you're in extended foster care is you kind of forego the SSI payment, usually for some period of time. But if you forego it for too long, you will lose eligibility. So what the workaround was, I know years ago, is and I'm trying to remember the intervals at which you do this. That's why I was trying to grab an old document to remind myself of the details. But there's a certain amount of time that if you go past, you can no longer be eligible for SSI. So what you do is for a month, you forego the extended foster care payment, you get the SSI payment, and that keeps you eligible. Then you go back and extended foster care. So I think, like David said, it's good to engage the attorney, because it can be a complex situation, and you definitely don't want the youth to lose eligibility for their SSI, but it's absolutely possible. Oh, and someone just said you need to claim SSI for 1 month a year. Thank you. So every year, I was trying to remember if it was like 6 months or so, it's 12 months. So I think it's really important to make sure this is done right and to engage the youth's attorney. So this is on their radar.
Right. And we're coming to immigration. And Emma, if you could go to the next slide too. I want to, again,
just want to say one real quick thing. So guardianship, all of the same things apply. It must be a guardianship established through juvenile dependency court. So a probate guardianship is not eligible for extended foster care re-entry. That's a different type of a guardianship. So that can become a little bit confusing for folks. All County Letter 1931 has extensive information about this process of re-entry for those who are in legal guardianships or adoptions. I encourage you all to read through it. What I had experienced through my practice when I worked in extended foster care is that one of the biggest challenges is actually kind of proving that adoptive or guardian parent is no longer providing support. So it's a great question to really bring to your local attorneys and county council, and to really partner in guiding that vulnerable youth through the process. So if anyone has successfully done it, I would love it if you want to share your information in the chat, because I will say the one experience I had, we actually were not able to re-enter that youth.
Right. And sometimes it's just a fight. But you're not good, Katie. You have in Fresno. Because it really shouldn't be a fight. I mean, again, just slow down, take a beat, think about why AB 12 exists, why extended foster care exists. And if you have a youth who was adopted through the dependency court prior to the age of 18, who was a dependent, and then finds themselves in a situation between 18 and 21 where they would qualify as a non-minor dependent, say due to death of the adoptive parents, the legislation allows for them to come back in. Are you going to get resistance? Maybe, hopefully not. And then we can get there. So do we want to get to Valerie's question? Or do we want to keep going?
I think we'll save it for the end.
Okay, fantastic. So yes, I wanted to put this slide up while we were talking because it just felt really relevant to what we were talking about in terms of eligibility expansion. And again, it's just very consistent with the purposes where kids were coming in 2 months before their 18th birthday. And there was just no way to be able to hold a disposition hearing, especially if you're in a larger county where juris dispos are put out for months and months. And we wanted the situation to be covered where these people, these youth who turn 18, who really need extended foster care, can access to them. So again, the intention is general expansion and inclusion whenever possible. So if you're having a youth eligibility question, you feel like they should be, you're probably right. So, and that's what all of these resources are here to give you the language and the authority to go forward saying, yeah, see, this thing says that. Let's go to the next slide. These next few slides are SIJS and immigration. And my plan, because we are mindful of time and we really want to get to your questions. So these next 5 slides, 6 slides actually, before we get to 391, I want to sort of take, generally, this is the immigration SIJS section of the webinar. I'm looking at my clock and I want to be done with it within 3 minutes. Not because I don't think it's important, but because I think it's such a deep topic that I just want to make sure it's all covered. The big bullet on this slide that I really wanted to help discover, there was a long-standing controversy for years among the 58 counties as to whose job was it. It's yours now, which is a really good thing because Minors Council were messing this up right and left. And your agency really can and should have access to experts, immigration attorneys and immigration specialists, and the resources are on one of these slides. And if your county does not employ or contract with immigration specialists who really understand this stuff, send us a note in the chat, we can connect you, that wheel's been invented. And so that's the lesson of this slide. Can we go to the next one? Right. Again, slow down, get to know your youth, dig deep, look for this issue. When it is flagged, it's a big flag. Stop immediately. I've got an immigration issue. I've got an SIJS issue. I know something needs to happen before I let them go and before they turn 21. The laws are all there. The help for you, the resources for you should be there. And let's go to the next slide. Yeah, I love this one. This is such a good, lawyers would never put this in. You could tell a lawyer did not write this PowerPoint. But this is actually the most important slide, so I'm going to slow down for a minute. When you're working with the youth, remember that, you know, the intergenerational fear of sharing immigration status. You're the man, you have, you know, the power. It's a very sensitive, important topic that can mean everything to them. And terrified, you know, these kids are terrified in general. You know, see if you can access the birth certificate and verify it to the extent that you can with them. Obviously engage their attorney so that they're not working against you. And then, yeah, you've got to make sure that the SIJS folks are doing their job too. So, you know, it's a tall task. And I always say that county child welfare workers really have the hardest job in all of child welfare because you serve so many masters. And unfortunately, this is yet another one because now you got to stay on top of these people. But it's really important. And, you know, you will change a life for sure. And generations to come, you know, the sea star story and the starfish story, that's this. Okay, let's go to the next one.
And I just wanted to emphasize that the law change, the practice change that is more recent is that you cannot exit a non-minor dependent until you have filed that application for special juvenile immigrant status. So there's always been a strong emphasis on that process, but it's more recent where it's really clear in, you know, those WIC 391 findings that you cannot get to an exit hearing for a non-minor dependent if we have knowledge that they don't have special immigrant status. So we really have to elevate our efforts to ensure that that's happening.
Right, Susan, great question. The answer is SIJS happens to the federal court. But what Emma was talking about is you cannot dismiss the dependency case, the state dependency case. The court has to have jurisdiction over that minor or non-minor dependent, both actually, but the NMD for this case. The court has to have jurisdiction over the NMD in order for SIJS to attach in the federal court. And so you cannot let, I mean, obviously when the youth turns 21, there's not much you're going to be able to do. So that's why there's some pressure to get this done before the youth turns 21, because you need that jurisdiction in order for the federal court to do its thing under SIJS. I hope that answers that. Okay. Yeah. I think we talked about this. Yeah, you know, document. This is just good stuff. Yeah, the TILP is really important. And so, oh, great question, Tasha. And then we can leave this slide up, and then in a minute, Emma, let's go to the next slide. Can you still dismiss if they're AWOL or MIA? You're not supposed to if they're on runaway, which is what we're calling them these days, right? And don't forget about your responsibilities to make diligent efforts to find these children, or I'm sorry, non-minor dependents, these young adults, because you have that obligation every month as well. So hopefully they don't stay MIA or AWOL or on runaway for very long. But when they are, you cannot dismiss, and you should not dismiss. Not until, well, actually, I'm going to defer to you, Emma, on this one, because they're not meeting criteria at this point. And Simone, I don't know if you guys want to weigh in. You could theoretically ask the court to dismiss because they're not meeting criteria. I will tell you, if you have an SIJS issue, if you have an immigration issue, do not. You will be hurting this young person if you dismiss with a pending immigration. There's no coming back from that. In cases where immigration is not the issue, that might be a choice you might want to make on a case-by-case basis because they're not meeting eligibility requirements at that point. So if either of you want to weigh in on this, that's a separate question. But I want to be very clear. If you're dealing with an immigration issue, please, you are doing such a disservice to the young adult, even if you can't stand the sight of them because they drive you nuts. Please leave that case open until they're 21.
Yeah, I would just say from my perspective, extended foster care is intended to be incredibly flexible. So someone could absolutely be meeting that participation requirement of participating in activities to overcome barriers, even if they don't have a placement, even if they're technically missing, you haven't heard from them in a couple of weeks, because their plan to overcome barriers could be something so simple as learning how to navigate the bus system, rebuilding connections with estranged family members. We really have, I think, slipped away from the intent of foster care, which is to create a robust safety net for the vulnerable youth and young adults who have lived their lives in our foster care program. So I think there is some certain timelines, there is some guidance around filing a request to exit a non-minor dependent if they are truly missing from care. You have made active, diligent efforts to locate them. You have a search log. You have gone to the depths of the world to try to find them, and they really are unlocatable. But I think that should be our option of last resort, because they're not doing any better if we just sort of let go of them.
Exactly. Yeah, let's head to the next slide. And thank you, Valerie. If you haven't seen Valerie's comment, please take a look. I think she's spot on, especially when we're not dealing with immigration. It's very different when immigration is an issue because we are beholden to the federal courts. Our judges have no power in the federal courts. We got to do what they say. We got to do it their way. Otherwise, this youth does not get the status that they actually deserve and are entitled to. So big difference. What I wanted to say about this slide was, yeah, if you can become familiar with the services available to the clients, the CDSS website has an immigration services funding grantee contact lists there. They have a removal defense program grantee contact list. In other words, CDSS funds lawyers to do this stuff. And the Immigration Advocates Network is on there as well. And the CDS website has all of that. So again, just an email to Emma. Sorry to volunteer you, but you're so good at this. She can connect you if you have any doubt. And then
I was just
think-
going to plug too, there's also 2 links in the resource document for Northern California resources, legal services for children based out of San Francisco. I worked with them to establish special juvenile immigrant status for a non-minor dependent who was on my caseload. They were phenomenal, wonderful, easy to work with. There's also a IRLC kind of immigration toolkit that's got tons of really helpful resources. Hopefully you all have connections with resources in the areas that you practice in, but if not, please check that resource document. And it takes time. It takes a long time to establish special juvenile immigrant status. So the soonest that you can get started on that for children and youth that you know need it, the better.
Yeah, really big deal. So as I take a deep breath, we're going to leave immigration. And if you have any other questions about that, we will come back to it. I'm going to talk about 391, and Susan, we're going to look at your question in the chat and get to that in just a second. Yeah, I want to talk about AB 674 and AB 546. Yet another thing you have to do for 391. 391's got to annoy you guys, but it's really important for us representing children and non-minor dependents and judges to have the checklists and to have those things. Thank you on behalf of all of us who read all of your work for filling out these 391 applications. They get longer every year, but these, of course, were also spurred on by real-life cases. And in fact, my office sponsored 546. 674 was requiring social worker. You got now have to provide CalFresh benefit eligibility. It's another box for you guys, but it again super important. The housing issue, we were seeing youth in certain counties that were not dealing with housing and not being addressed, and so we were sending these young ones out into the world without knowing whether they would have housing or not, and so it was easy to codify 391H7. Talking about we have to figure out if these folks have a place to live or not. So let's go to the next slide. I know I'm wrapping up my portion here, which is good. I think we're running right where I want to be. Protections for minor and NMD parents, again, to ensure a more strength-based assessment of what's going on. So we have 361.5.
I think, David, I think this is my slide. So if you want me to grab it, I can, but I'm happy to refer to you if you want to cover
I'm so glad. I'm just looking at this going, I did not prepare on this one. And now I know why. So all yours, Simone. Thank you, guys.
Okay. So AB 670 was based on this idea that foster youth with children of their own are under, generally kind of more scrutiny than youth that are not in the foster care system that are having children. In terms of, kind of potential mandated reporting, they're around a lot of mandated reporters. There's a lot of people in their lives that are, for better or for worse, right, that are there and present, that are thinking about their relationship with their child. And they are young, they are teens, or they are young adults. And so, this is a controversial topic. People want to protect children, but they also want to make sure that they protect the rights of youth and young adults, and give them a fair shot at parenting. And so it's tricky. So AB 670 was really based on this idea of there is increased scrutiny. We know that. And so it really it attempts to establish kind of some new protections for parenting foster youth. There's a lot of existing protections that it really built on and then expanded them a little bit. And I really suggest, if you want to understand this in depth, is read the ACL on it, because there's a lot in there, and I'm going to kind of sketch, provide a broad sketch of it, but I recommend reading the ACL. So number one, the legislation requires a social worker or probation officer to use a strengths-based approach to support a parenting dependent in providing, a safe and permanent home for their child. And that's very practicey, right? Like, it's hard to legislate things like a strengths-based approach. So this is where, obviously practice really comes in. Really the idea of, if there's an investigation being conducted, really, how do we use a strengths-based approach versus a very chastising approach? The other thing it does, a big thing here, is there were obviously some requirements about noticing attorneys. And so what this did is it requires any law enforcement agency and county welfare department or probation department to notify the attorney of a parenting dependent within 36 hours. So that's new, the 36 hours piece of receiving a report alleging abuse or neglect of their child. And while this 36-hour window provides an opportunity for the attorney to provide legal advice and support, I think it's important to point out the requirement to notify the attorney shouldn't delay the county's response to priority for referrals requiring an in-person investigation. So we're definitely still, trying to keep children safe here. And so just keeping that in mind and balancing those rights and protections. It also extended, like I said, a number of existing safeguards for parenting dependents and wards to also include non-minor dependents. So like Emma said, a lot has changed with extended foster care. So there were protections in place for parenting minors, and sometimes we have to go in and do cleanup legislation, to make sure that these things are also extended to non-minor dependents. For example, it amended the law to specify that the provisions authorizing sort of a bypass of family reunification services based upon a prior determination of family reunification or parental rights does not apply if the only times family reunification or parental rights were terminated occurred when the parent was a minor parent, an NMD, or a judged award of the juvenile court. Again, I know it's like kind of a mouthful. I really recommend reading the ACL to fully sort of understand what it's saying. Also, a party seeking an involuntary foster care placement or termination of parental rights over a child born to an NMD parent at the time of the child's birth must demonstrate to the courts that reasonable efforts were made to provide remedial services designed to prevent the removal of the child, and that these efforts proved unsuccessful. So those are some examples of sort of the existing safeguards it builds upon. It also, there are provisions sort of authorizing the denial of family reunification services, and those are not applicable in the case of a non-minor dependent parent unless certain circumstances are met. You can read more about those kind of in legislation. And then it doesn't allow for, or I already said that one, sorry. So yeah, so there's a bunch of existing protections that it sort of extends to non-minor dependents, and there's a lot in that ACL if you want to visit it. So the next slide, if we want to go, there we go, to this one. This one is AB 153 was a budget trailer bill. So budget trailer bills are huge bills that jam a bunch of stuff into them. So they contain like a number of different topics. They're not like policy bills where the whole bill is on that topic. So this was a budget trailer bill. It included some provisions that made changes to court findings and sort of what the court forms say. And it really supports implementation of previous legislation that passed in 2017. That was the California Foster Youth Sexual Health Education Act. And that was also called SB 89, which was a different budget trailer bill. SB 89 did 4 things. And so it's important to understand what those things are to understand where these court forms come in. So SB 89 required social workers to ensure that all youth aged 10 or older enrolled in middle or high school are receiving what's called comprehensive sexual health education. And it has to meet the requirements of the California Healthy Youth Act, which is something that applies to all young people, not youth just in foster care. That legislation requires students, public school students, to receive comprehensive sexual health education at least once in middle school, once in high school. What we were seeing as foster youth were missing these courses due to high school mobility, a lot of moving. They were missing, like it was out of sequence, or they were absent, for some period of time. And so we know that foster youth, when you look at research, we had hit a 30-year low with teen pregnancy for the general population, but not for foster youth. So there was a lot of discussion about how do we assist foster youth in also making informed decisions about family planning, and not moving forward if they do not want to with certain things in life, including pregnancy. So having choices, knowing what their rights are, and doing good planning. And so part of that was getting correct sexual health education. And so SB 89 requires the county to really verify that they've received that through school, and if they haven't, to get it in alternate methods, or to get it from the school out of sequence. SB 89 also requires youth case plans to be updated annually to indicate the social worker has informed youth of a bunch of different things. One thing is, letting them know you can access age-appropriate, medically accurate information about reproductive and sexual health, and that they've been informed that they can consent to their own care and have a right to confidentiality. SB 89 also required CDSS to develop a curriculum on reproductive and sexual health for social workers. And then there are training requirements in SB 89 for judges, social workers, pre-approval training for resource families, and then STRTP administrators certification training. And so all that to say, AB 153 has provisions that really develops accountability for all of those, the provisions that I just listed. And one way it does that is it changes the court forms. It makes court findings really look at whether these things have happened. So you can see on the slide, these are some of the things I mentioned that were in SB 89. We were seeing across the state that a lot of these things weren't happening. And so the idea here is, let's make sure there's just some accountability in the court systems for making sure that young people are getting the things that they're sort of intended to get via SB 89. So I know that was a long one, but it sort of required a lot of history in there. Let's move on to the next. And then this slide really just expands on the last one, I'd say, in terms of what social workers are informing youth about. There's obviously a lot in here. When you talk about sexual and reproductive health, it's a topic not everyone's comfortable talking about. People have a lot of different feelings about it. Some people don't love the idea of having a 10-year-old be in a sex ed class. I know parents that don't have youth in foster care that have, their children, that they're like, my kid's getting sex ed in school this young. There's a lot of different opinions about this across our state. But regardless of what all those opinions are, this is what the law says. And it is research-based. I do want to reassure people it is research-based and in producing good outcomes. So I really recommend reading ACIN I-0620. It has talking points for social workers related to how to talk to youth about these difficult topics, uncomfortable topics at times. And I think it's also really important for social workers to know sort of what their obligations are in this area. So one thing that's good to know is that minors and NMDs can consent to medical care without consent from a parent regarding prevention or treatment of pregnancy. And that could be contraception, pregnancy testing, prenatal care, abortion at any age. Okay, they do have that right to consent. Healthcare due to rape or sexual assault at any age. Prevention or treatment of STIs or HIV prevention at age 12 or higher. So these are really kind of key things to know that are in the law related to kind of confidentiality and consent. Another thing people often don't know is the medical provider must have consent from the minor or the non-minor dependent before disclosing information to the social worker or a provider or anyone that goes in there with them. So you can't just say, okay, I'm coming in on a doctor's appointment with you. The doctor's going to say, let's get the youth's, let me talk to them privately, or let's get their consent for that. They have the right to private medical appointments. And then the information shared can't be shared with others except as allowed by confidentiality and privilege laws. So if just abuse or neglect or exploitation is disclosed and there's a health and safety risk currently to the youth. So we could go on and on about this topic. There's a lot to talk about, but again, I recommend reading that ACIN because it's really, it's also really important for knowing how to document the information. And I forgot that's on the slide too. is you have to be able to document these things in a way that does not violate confidentiality. There's some generalized ways to do that. One example is, well, first of all, you have to redact some things if there's private health info in the case file, but sort of entering information in the CWS CMS. For example, you could say the youth is under treatment for a sensitive health matter. So you're not getting into the nitty gritty about what STI they might have, right? Or this pregnancy status. So I would, again, recommend looking at that ACIN for more context. And Emma, I think I'm passing it to you here for the next one.
Great. Thank you, Simone. Just want to really appreciate everyone who's really engaging through the chat. So many excellent questions. I love it that you all are sharing strategies, resources, responding to each other. So please keep that chat flowing. So there are some existing and expanded opportunities and requirements around gender affirming treatment and services. So AB 218, there was some bills passed in 2018 that really helped to clarify that foster youth have a right to access to gender affirming healthcare, that's part of their foster youth rights, their opportunity to collaborate in the development of their case plan. WIC 1601.2 affirms that they also have a right to healthcare and mental health care that includes gender affirming care. There is a recent all-county letter that came out in 2023. It's ACL 2309, which is linked in your resource document, that shares that there is now the ability to do a name change in CWS CMS to support a foster youth or non-minor dependent's gender identity, which I think is super exciting because prior to that, there was a fairly complex court process that social workers had to follow to be able to really honor that name and identity of a youth. So now we have some ways of doing that in, I think, a way that feels a whole lot less invasive, stressful, and traumatizing to really honor who that child or youth is. So great resources, again, on this topic in the resource doc. Check it out. And if any of you are following that process, if you're utilizing the guidance of that new all-county letter, we'd love to hear you talk about it through the chat. There's also a great several different ACLs and ACINs, and this is also, again, reinforced through the Foster Youth Bill of Rights that state that a foster youth has a right to be placed according to their gender identity. And all of this work is extremely important because we have disproportionality of youth who are LGBTQIA in our foster care system. So there are proportionally more of them in out-of-home placement, oftentimes related to rejection from their family of origin. They don't tend to fare particularly well in our placement system either. So the more that we can do to really be affirming and trauma-informed with how we work with those youth in our system, I just think it has the potential for real healing and transformation.
Oh, sorry, go ahead, Emma.
No, go for it. This is you.
Yeah, so before I was answering this in the chat and I realized I won't be done typing by the time we get to this slide. So I'm just going to say it out loud. So in regard to the comprehensive sexual health education, because this is, I mean, we've had whole webinars on this topic. It's a huge thing. I'll just say there's not a perfect answer in the sense that there isn't some amazing documented process that's happening statewide. It is county to county, district to district, unfortunately, sometimes school to school. But they do need to, like, as I think, David's pointing out, it is state law that all youth in public schools, in middle school and high school, are receiving a very specific level of comprehensive sexual health education. It can't be like wackadoodle sex ed. It has to be factual, medically based, not just someone making stuff up, right? It really is there's a high caliber or a high expectation of what this is. And it has to cover very specific things. It has to cover self-esteem. It has to cover a whole bunch of different things. And so the schools, the districts, not the schools, the districts are required to offer this. And so they do have to track when, like it's in science class, second semester of sophomore year, like they have to be able to provide that information. So if that's not happening in with the districts you're working with, there's something wrong going on in that district, and that should be addressed generally. But there are some counties and districts that I think have worked out good communication systems for documenting this, but it's definitely been the bumpiest part of SB 89. It has not been easy. It's been difficult because it's out of a county's control that their district is complying with them and giving them this information. Like it's one of those things where you're sort of being mandated to make someone else do something they don't sort of have to do for you. So it is tricky. But it is not, I just saw Julie's message, it is not listed generally on the transcripts because they don't want to out young people as sort of in that public manner of, we have to note when and where they receive this, or this youth is a foster youth. So we have, so there's been reticence to include something on transcripts, I know, in a lot of cases. But it is about meeting with, and County Office of Ed can help, but meeting with the districts and getting a process underway. So I know that's probably.
And I just want to share that Foster Reproductive Health, incredible organization in California. They've done a ton of work to create a really fun, engaging, I had a chance to preview it, live virtual course called Teen Talk for Foster Youth. It's a free virtual sex education course for those who are in foster care. Put a link through the chat. They have multiple series that are open and available. I know a youth who was 13 who took the class and said that the information was super helpful. It was actually really fun. There were good connections made with other learners in the class. So if you have a youth, especially who may not have stable placement, they're not actually, in school for very long, we just can't really tell if they're getting access to this crucially important information. I highly encourage you to check that out.
And I should add, I saw a question, I forgot about this one, where someone said, well, kind of like, are social workers expected to provide this? Like, that's kind of wild. Absolutely not. It is not recommended that a social worker is like, I'm going to teach comprehensive sexual health education. It's an extensive amount of information, and the people who are sort of certified to deliver it are certified to deliver it. And we wouldn't, I don't think people would expect social workers to, oh my goodness, put on a thousandth, like how many hats does everyone wear, right? Another hat. So you really do want to refer out to it. And there are in a lot of cases, Planned Parenthood offers this level, of course. There's also PrEP providers, which I won't go into detail about what those are, but they're just essentially publicly funded entities that offer this type of education. Sometimes PrEP providers are Planned Parenthood. PrEP is just an acronym for the program. But if you can't find one in your area, I strongly, again, like Emma underscored, there's amazing stuff available virtually. So it is out there. And if you need help plugging into it, definitely reach out, because I absolutely would not recommend trying to take that on yourself. So now on to what the slide actually says. So expected parent payment. So this is something that we actually worked on, that we at first thought, well, let's extend the infant supplement to pre-birth, because that seems important. Like, we want youth to be prepared to have their children and have all the supplies they need, but they don't get the infant supplement till the child is born. So we wanted to make like a pre-infant supplement. Then we learned the infant supplement in federal law is very specific to, it starts at birth. So we couldn't call it a pre-infant supplement, or we couldn't call it an infant supplement, something else. So we had to call it an expectant parent payment. So that's why there's sort of two distinct different things, but it's essentially the same idea as an infant supplement. It just starts 3 months prior to the due date. And the idea was that it would be equal to the amount of the infant supplement, which is $900 a month. Where we ran into, where it got tricky, was with the automation. You guys all probably know when things change with payments, they have to get automated in what's now CalSAWS, and that takes time. And so because of how long this was going to take, they said, well, let's prior to automation, we'll just pay in a lump sum of 3 months worth of $900, which is equal to $2,700. You can see on the screen. And when it's automated, then the parent will start be paid monthly, the $900 monthly payments in those 3 months. Now, I double checked. I've checked around with a couple of counties. My understanding is automation has not yet occurred. Now, a lot of times with CalSAWS, they'll give you a date and say, we're trying by this time, like July 1, 2023, which has obviously passed, or when our systems are ready and complete. So a lot of times we don't necessarily see things roll out on that target date. And my understanding, at least I know in LA, it has not been automated yet in terms of receiving 3 separate payments. I don't know if anyone on the webinar has had a different experience in their county and it's already being done in 3 separate payments. I also know this is incredibly rare. You don't have youth getting pregnant every day that are, in this situation. So you may have only seen this happen once in your county since it's been implemented. I don't know. But I don't know if anyone has a different experience in their county in terms of the automation being complete, please speak up. We'd love to know. So I will go on to the next slide. So like I said, it starts in the 7th month of the pregnancy or later, like if youth don't disclose till later, or if somehow they didn't know, but it'll start whenever they do find out, 7th month or later. They don't like lose it if they don't know by the 7th month, or they don't notify by the 7th month. Part of the oh, thank you, Valerie. Yeah, still lump sum. Sounds like it's lump sum everywhere still. So part of the idea of the expectant parent payment wasn't just resourcing young people with money to purchase things for their baby, was also to encourage disclosure, right? We know that the prenatal care rates of youth in care when they get pregnant are lower than the general population, and we definitely want to see that change. We know that prenatal care is so important. And so part of that is making sure that the social worker, a provider, the attorney, foster parent, somebody knows that this young person is pregnant and can connect them to prenatal care. And so part of we're hoping, if young people know there's something they're waiting for them, a resource, they'd be more likely to disclose if there's someone who's in a situation where they're scared to disclose, nervous about being judged, whatever it may be. So that's part of this. But they still do get it if they disclose after the 7th month. They do have to have an open case and an approved placement. So, current foster youth. And again, this depends on your county policy in terms of how you pay out, but it could be a check, a debit card, or electronically. You do not have to get any receipts from young people. They don't have to prove what they're purchasing, or, there's no kind of official monitoring of what they're purchasing. Of course, we'd like them to be assisted in making good decisions, but there's no proof. You don't have to collect a paper trail. All the items purchased belong to that non-minor dependent. They can't be confiscated or anything like that. And however, the county can request a verification of pregnancy from a medical provider, consistent with confidentiality laws, of course. Next slide. So obviously here we want to use a strengths-based approach. This is another tricky situation where, okay, a young person becomes pregnant. We know what a big life-changing experience this is and how important this experience is in terms of it being done well. And so, and it's a lot on a young person. It's a lot on someone of any age. So there's a lot of practice support for, this vulnerable time where young people are pregnant. And I encourage you to look at ACIN I-4522. We also have a toolkit that we developed years ago for social workers around the expectant parent payment. And it's in that resource document that Emma mentioned earlier. But it's really important that youth are, just like with receiving the SILT payment directly or receiving the infant supplement directly, that they're assisted with budgeting. We know that any young adult needs some guidance and assistance there. So how do you help them budget? And then how do you help them make good purchases? Also, if they've never had a child, they don't necessarily know what to purchase. They need a lot of guidance and support. So, it's recommended to use CFTs before and after birth to kind of wrap around that young person, ensure their needs are met. And again, they're helping them budget. There's a kind of a template in a budget worksheet, they call it, in the ACIN. All right.
I just wanted to say that Tasha shared in the chat that they attach a family service worker with the payment. That way the young person has a person to help them shop with a baby list and transportation. It's an automatic process and kiddo can decline. That's so cool. Thank you for sharing that, Tasha.
I love it. And I'll just kind of pop in, and say, I don't want to slide on this, but I just want to say one thing that we really recommend is exactly like what Tasha's saying, which is have some protocols. This doesn't happen a lot. There's not a lot of youth getting pregnant in care in terms of sheer numbers, right? have a written documented protocol. What happens when a youth gets pregnant? We refer them to home visiting. We get them for, not in this order, we get prenatal care, right? Refer them to home visiting for when they have their child. We hook them up with the public health nurse that's assigned to them in their county. We make sure that they hook up with the expected parent payment. We help them get certain supplies, right? Like there's all sorts of different things. Maybe they get in parenting classes. There's all sorts of things you can do sort of to help set them up for success. And I really recommend, because this is not something that we do every day, right? To have a strong protocol in your county that includes whatever you think, whatever, all like what Tasha said, get them a family service worker. Do whatever you can to support this young person.
And I'll just add too that I've heard of counties who partner with youth to host a baby shower or a blessing way or some type of an event to really celebrate that transition into parenthood, which may at first seem like an illogical use of these precious funds. But when we think about what's actually really important for people as they transition into parenthood and adulthood, it's relationships, it's connections, it's someone who can come over after you give birth and you're exhausted and you've been up all night, who can hold your baby so you can take a shower. So partnering to create some event like that can also be really beneficial for that connection to crucial supports.
Absolutely. And the public health nurses are a great resource. I just want to underscore that. I think they're underutilized, in my opinion. It's like, use them. They know what they're doing. This is what they do. The infant supplement. So I think that I kind of let the cat out of the bag before. The infant supplement has been around for a long time, and it's a payment that supports young people that have children, and not just infants. It starts, at the infant stage when the child is born, but it continues on. So for youth that are in care that have their own children, they get a payment every month, or if they're with a placement or a caregiver, that placement or that caregiver gets the money, and they generally pass it through depending on the placement. And just to clarify, this is not just for female youth. This is for females and males. So it's obviously way less common for the male to get the infant supplement. But if he has I'll say it like this: if both the mother and the father are in foster care, they can't both get the infant supplement for that same child. One of them gets it. Usually ends up being the mom, for kind of obvious reasons. And then if you have the dad is in foster care and his partner is not in foster care, he can get an infant supplement, if he's providing care for this child, to care for this child. So just make sure that's something you're kind of asking about when you're working with young men, because it, for obvious reasons, it gets looked over a lot of times.
Just want to make sure folks know, I'm sure they do, but it's not just for infants, it's for a child of that youth, regardless of age. So we had a youth who had a 7-year-old who was receiving an infant supplement.
Exactly. And the placements, so in terms of who gets it, so youth that are in SILPs, that they can get their SILP payment directly, they also can get their infant supplement payment directly. It also, for youth in THPNMD, it does go to the provider, but there was guidance the state has provided that says they either need to pass it through, or they need to engage in a written arrangement, an agreement with the NMD, or with the NMD, because it's THPNMD, to how much is going to be passed through and how much is going to be retained. Because frankly, I mean, the THPNMD providers, they often provide most of the supplies for young people that are parenting, and so there's a lot less to purchase. So sometimes they split some of the payment to cover those costs. And then if it's a foster parent, it does go directly to the caregiver. And again, they can develop an arrangement where some of it can go to the young person, depending on how heavy-handed that caregiver is in providing, a crib, car seat, all those different things. So those are really individual sort of arrangements. So in terms of how much it was for eons, it was $411 a month. We worked on increasing that through 4 or 5 years, more than that, 6 years ago. I don't remember. It was a while ago. And it is now $900 a month. It does not increase like foster care placements do annually. There's no CNI increase. It's just a flat rate until it's changed in law again. So it's $900 now, and it will be until someone changes it in law. All right, passing it back to you, Emma.
Sorry, my unmute button keeps on slipping away. We're going to try to move quickly because my goodness, we still have so much less, but I just want to introduce, Simone's going to talk a lot about housing, but it's really important to put at the outset of this conversation that social workers have some key obligations regarding housing for non-minor dependents. The first one is, like any other child or youth, we need to always be offering the least restrictive, most home-like environment possible based on that non-minor dependent's needs and their independence readiness, which should be done through an assessment process. Non-minor dependents must be included in placement decisions. We should not be deciding a placement for them. We should be engaging them in the process of picking the best placement arrangement for their needs. While they are under juvenile court jurisdiction or a party to a voluntary reentry agreement, we must offer a safe, suitable placement that is immediately available. So there should be no waiting period, no period of time where we're trying to do a reentry process, get paperwork sorted before they are able to access safe and stable housing. There should be no delays in signing the SOC 163. That's that voluntary reentry agreement for a non-minor who may exit extended foster care and re-enter. Once it's signed, our obligation to coordinate and arrange housing is immediately effective. So I know that this is a challenge in a lot of our regions that don't necessarily have a lot of immediately available placement options for youth. So Simone's going to go into quite a bit of detail about some of those expansions that the state has attempted to make available to help to meet that need.
Sorry, now I was muted. Yeah, so I'm going to try to go through these quickly, but I just want to say all of this housing information, like there's a lot. So feel free to, if we don't go into enough detail, feel free to email me directly if you want. And I'm happy to talk, be on a phone call or email, respond. This is the area that I probably work most closely on, and I'm happy to kind of do a deep dive with people at a later date. In terms of AB 592, so there's no ACL on the changes in this bill. So I don't think there's a lot of awareness about it, but it didn't do like huge things that are like life-changing things. But it made some nuanced changes to placements for NMDs. So first, it allows resource families to serve as host families in transitional housing placements for non-minor dependents, THP-NMD. So now a family can be both a foster family, for example, and also a host family without going through sort of additional certification because they're already cleared as a resource family. So that's one thing, just kind of cut through some of this administrative madness, right? It also authorizes THP-NMD providers to provide supportive services to youth in placements other than THP-NMD. So this is something where you kind of put your creativity hat on. You're like, how do we make the most of resources in our counties? Well, here's something to think about, right? So first they can provide services to youth that are in FFA homes. That's one. The second is they can provide services to youth in any supervised independent living setting. So that's the federal category, not a SILP, but a SILS. SILS is the federal category for sort of our new NMD placements that were established with AB 12. So the supervised independent living placement, the SILP, and the THP-NMD, and then a newer one that's only a year or so old is the transitional living setting, which I'll talk about in a second. But so this legislation said THP-NMD providers can provide services to youth in SILS. So across those, essentially, all those placements I just listed. And next slide, we'll talk more about the that new setting. So this is again. There was 2 supervised independent living settings in that category, 2 placements in that federal category. Now there are 3. So there's a SILP, and there is THP-NMD, and then there's the new transitional living setting. Next slide. The transitional living setting is really an emergency placement. We lacked emergency placements, as all of you are well aware, right? We get in these pinches with young people where there's not a viable placement. You can't find a placement for them. What do you do? So this attempted at helping out in that area a little bit and making some short-term placements that don't need to be approved, don't need to be licensed, are very flexible, and where you can still, the money can flow, right? Like you can still tap into that foster care placement and kind of in an emergency or just short term, you need something temporary. Doesn't have to be an emergency, but I'm kind of calling it that because we have those and we kind of lack placements for those. It can include hotels, motels, other short-term living situations. It's not, like I said, it's not subject to approval. It's not subject to licensing. Counties have significant discretion in determining what a transitional living setting is. The only thing is it cannot include a homelessness prevention center, which is essentially what we've recategorized homeless shelters as. And that's because those are not eligible placements for foster care funding. Now, I want to give just an example of when I said counties have significant discretion. One county, LA, has operationalized this placement in a way other than hotels. They have contracted with a provider called Optimus Youth Homes, and they have a campus, and they basically have studio apartments where the county has contracts, holds these provides them a monthly payment to hold these slots for youth that just need housing right then and there temporarily. And these aren't just like youth that can only be in highly independent living settings. These are young people who are coming out of drug rehab, young people coming out of group homes. They're working with a very high level of need and support. So they're doing that they have sort of a resource center on that campus. They have mental health clinicians because they have mental health contract. So this is a very robust, supportive setting, but it's not congregate. Youth have their own living unit. They do not have a roommate. That's part of the reason I think it's successful. And it costs money, obviously, but if you are looking for a more robust and a more formal way to kind of operationalize this new transitional living setting, and you have a provider that's pretty, like high capacity and can offer something like this, I'd really consider tapping into this new placement type. They negotiated a monthly rate, and that's what they're doing. And I just wanted to let you know that this, I don't know, I know some of you participate on the CWGA TAY subcommittee call. We have asked this program to come present on the next one later this month. So if you want to learn more about that, the way this placement looks in LA, join that call and you'll get a full presentation from them. Okay. Yeah, Emma, you're on.
Sorry about that. Thank you. So just some information here around some recent additional flexibilities around approving a SILP placement. So the county has had a requirement to always assess for the non-minor dependents' readiness for a SILP placement and the physical unit of that SILP placement itself, whether that's a safe, viable, healthy living environment for that youth. My understanding is that in many counties, a SILP placement is the primary placement available for non-minor dependents. And we just want to re-emphasize that a SILP placement is intended to be used for a non-minor who may actually have more capacity for independent living and independence. And a THP NMD placement offers typically additional case management and support. So it's really important to actually be assessing for the appropriate type of placement and partnering with that youth to figure out what supports they need. So recently passed AB 1979 stated that we no longer need to do an annual SILP assessment if that non-minor dependent remains continuously living in the same SILP placement. A county can still elect to certify the safety of the SILP every 12 months. So if they want to follow that annual inspection process, they can. And one of the great things about COVID is that we learned that we can do a lot of things virtually. I was carrying NMD cases during COVID at a time where multiple youth were living in out-of-state placements and bouncing around from home to home as young adults often do. So we were able to start using Zoom calls and video conferencing to actually move through that SILP inspection. That allowance has been continued, and we now have the ability to do those video conferencing telephone calls to inspect and approve a SILP using that updated SOC 157A form. And those required forms only need to be completed upon a new SIL placement. So hopefully a little bit of a reduction around some of that. I think this is you,
All right.
Simone.
Yes, so AB 1979 requires counties to conduct an evaluation of the county's placement resources and programs on a regular basis. So the idea is, do we have what we need in this county? Are we meeting all youth's needs? Do social workers have kind of their toolbox of placement tools? Is that toolbox full? And so, you know, placements that are out of county have to be identified, and then, you know, how many out of county placements there are, and then what the reason the placement was necessary, what needs to happen to bring, you know, the resource within the county. So trying to, you know, limit out of county placements where possible and sensible, the ability to meet emergency housing needs, so that non-minor dependents have access to immediate housing upon re-entering foster care or for periods of transition between placements, and then including the reason for the out of county and out of state placements in CWS CMS. So that's AB 1979. And then this is about really holding beds in THP-NMD. We had situations where youth, you know, these are young adults, they'd leave, maybe go stay at a friend's house for a night. And there was some different practices in terms of like, is that okay? Is that not okay? Is that normal? Well, yeah, it's pretty normal for young people of that age, but how do you handle it in a foster care world? So to sort of prevent housing instability where a youth kind of comes back to their placement and they're like, oh, we thought you just left. We gave your placement away essentially. So to avoid that, a county is authorized to continue to approve payment to a THP-NMD provider if the NMD has been absent for up to 14 days in a calendar month. So that sort of sets some parameters. If the NMD provides notice to the THP provider of their intent to return within 14 days, or if the provider has reason to believe that the NMD will return within 14 days. And if the payment continues, the THP provider obviously cannot provide a removal notice or fill the NMD's place in the program because they are being paid for. Next slide. So the housing supplement for THP-NMD. So this supplement, this is a new policy that was established in 2020. Implementation was phased across 2 years. At this point, all counties, this is in effect in all counties. It established a housing supplement to ensure that the state's housing crisis doesn't sort of compromise access to what is really the supportive extended foster care placement, THP-NMD. It supplements the rate paid to providers operating the program to ensure that they have adequate funding to cover rent. So what each county receives is different depending on the cost of rent in their housing as per HUD's fair market rent standards. And the nice thing also is that it provides an even higher amount based on a larger apartment size, according to FMR, HUD's FMR, for parenting youth. So it acknowledges, yes, we know providers need more funding to house parenting youth, and we don't want them to not accept parenting youth because it's not in their budget. Like that would not be good. So it addresses both of those issues, and I should say that it's based on the county of location and not county of origin. This is based on where the youth lives. I suggest reading the ACL about sort of how you handle this across counties, where one county is the paying county, but they're living in another county, just because we don't have a lot of time here for me to cover that. But I should also say the supplement amounts are listed in the annual CNI increased ACL that's released each year for foster care payments. So you can look at your county's amount there. The expansion, next slide, the expansion of the housing navigation and maintenance program. So this was initially a $5 million program that was established in 2019 called the Housing Navigators Program. The goal was help youth in care find placements, like a youth in a SILP needs help finding their placement. And so it was really set up for that. In 22-23 is the first year that the budget was increased and the parameters changed. So we fiddled with this program to make sure that counties that wanted to access FUP or FYI vouchers, which we'll talk about in a second, for youth in their counties had funding to serve these youth, because the voucher is covered by the housing authority, but counties were supposed to provide these services, and there was no designated funding for it. So we expanded this funding by $8.7 million. It's now $13.7 million annual budget. We called it the Housing Navigation and Maintenance Program to kind of services / housing navigation, and increase the upper age limit. So it's really 18 to 24. So it can cover youth out of foster care as well, and expanded the priority population to include former foster youth as well. Next slide. So the Family Unification Program and the Foster Youth to Independence program, FUP and FYI, these are, is everyone familiar with housing choice vouchers or Section 8 vouchers that HUD administers to public housing authorities? So these are Section 8 vouchers, especially for transitioning foster youth. And FUP also, as you probably know, is available to child welfare involved families. There's like a leg of it that came out for youth, and it's been around since the 90s, the early 90s. And Foster Youth to Independence, FYI, was launched in 2019 solely to assist young people. So when you hear people talk about FUP for youth and FYI, they're essentially the same thing. It's I just at this point say FUP / FYI because people refer to them interchangeably. It's very confusing. The cool thing about FYI is that it's administered both on a traditional competitive process through ANOFA. It's also available on an on-demand basis, which I'll talk more about in a second. Next slide. Now, FUP and FYI eligibility and administration. So this is youth 18 to 24 inclusive, so just have not turned 25. And then youth have to either have already exited foster care or be exiting within 90 days. So these are a critical tool for your 90-day transition planning period, right? Because youth can be gearing up to exit and they don't have a housing plan. Well, guess what? You can get one of these vouchers now. So this is really a tool for social workers in that 90-day transition planning. I can't emphasize enough. The eligibility also says you have to be homeless or at risk of homelessness age 16 or older. Don't even scratch your head about that. I know it doesn't make any sense. It's for youth 18 to 24. HUD's language is very wonky, weird, but all youth coming from care are considered at risk of homelessness. So it's essentially youth who are 18 to 24 and have exited or are about to exit. The program provides a 3-year housing voucher, so a deep rental subsidy that housing authorities provide, and it's coupled with supportive services that the county child welfare department either contracts for or provides or secures. And youth can extend their voucher for another 2 years, so a total of 5 years, if they either opt into this other program, family self-sufficiency, or they do participation conditions very similar to extended foster care. So it's essentially, it can be a 5-year voucher. Okay, so the on-demand function, and this is my last thing here, is that, so again, you can get it traditionally, you can write a proposal, or the housing authority can write a proposal, get it from HUD through that competitive normal process. And there's also a process where literally the child welfare agency says, I'm going to just pick on Stephanie here. So Stephanie Sandmeyer is, she's at risk of homelessness, she's leaving care, or she's already left care. Here's her information. You send it to the housing authority, and the housing authority takes that, submits a form to HUD on behalf of Stephanie and says, give me a voucher. They take maybe a month or two-ish, send the voucher over. That's it. They can be requested in intervals as small as 1, or we could get them as large as in batches of 25. A housing authority can get up to 50 a year, a fiscal year. So if you're not already, and I think we can go to the next slide here. If you're not already, well, so first, let me back up. We have a roster. We just released this. This tells you who the point of contact is in every county for these vouchers. So check that out. And then if you have vouchers, again, key tool for the 90-day transition period, a resource for youth leaving THP+. And then if you don't have vouchers, I really encourage you to talk about this within your county. Approach your local public housing authority about entering into a formal partnership. All is needed is a letter of commitment or an MOU, and you guys can start doing this. And there's federal money. It's available on demand until it runs out, and it keeps being appropriated.
Simone, quick question, 2 questions.
Yes.
Do probation youth qualify?
Yes, they do. Great question. I will say it is very underutilized by probation for obvious reasons. It goes through county child welfare. So where's all the outreach going? Going to foster youth, right? But I really encourage you to talk with your probation partners and say, this is a resource for you. Send us referrals. We can get you a voucher. So yes, out of home probation youth, it is same thing. Okay.
One more. If the
Yes.
youth wants housing, they're not in the county that has
Mhm.
jurisdiction,
Yeah.
do they then approach housing in that county or in the
That's
county of?
That's correct. So they're just like their Section 8 vouchers. So if you know, and this person might know about that. So you've got to live in the county or the city of the housing authority. So if it's like City of Oakland Housing Authority, you've got to find housing in Oakland. If it's County of Alameda Housing Authority, you got to find housing in Alameda County. So it goes by the jurisdiction of the housing authority, whomever the child welfare agency is partnering with. After a year, youth can what's called port their voucher out to another housing authority. But that voucher then gets absorbed by that new housing authority. So in the case of Stephanie's in Sacramento. If Stephanie ported after a year her voucher out of Sacramento to Alameda County Housing Authority, Sacramento would lose that voucher. Alameda County would gain a voucher because when Stephanie's done with her voucher after 3 to 5 years, it recycles back into that housing authority. So just know about that porting, but that's an option after a year. So youth need to go where they live or where they want to live and get a voucher. Okay, we should move on to THP Plus, and I'll try to breeze through this as quickly as possible. I'll just say that THP Plus is for former foster youth. It's supportive transitional housing. It was recently, the program was lengthened. It was a 2-year program. It is now a 3-year program. It is in most California counties, about 47. It also increased the upper age limit 1 additional year. So it's up until you turn 25 now. We also increased the state budget that's been feeding into this program. In addition to the realigned THP Plus dollars, you all have from 8 million to 33.3 million. So these are big expansions. So I recommend you checking in with your folks within your county and saying, have we increased our capacity yet? Because we want to make sure we're spending down those new dollars. You can view your total transitional housing budget at the link on the screen. I am going to pass it, I think, over to Sarah. Emma, is that right?
All right. Hi, everyone. My name is Sarah Potter. I'm a senior project manager at JBay, and I work on the education team. And I'm very lucky because I get to work with Simone often. Even though we are on separate topic areas, we collaborate a lot. I'm also really excited because first of all, I'm a very excitable person, but second of all, I love talking about foster youth and education, especially around post-secondary supports and post-secondary resources. I am a former foster youth. I spent 17 years in the foster care system in San Diego County before I matriculated into higher education and really benefited from the Guardian Scholars Program at San Diego State University. And so I am your go-to person for all things foster youth and higher ed. Before I jumped in and start talking about legislative changes and resources and all of the happenings in the post-secondary and K through 12 world, I wanted to share some data with you all. So we did a research study and found that 86% of foster youth indicate that they want to go to college. And this was a survey that was done while they were in high school. However, upon graduation from high school, only 55% ended up enrolling in a 2 or 4-year program. And then only about 10.8%, I rounded up, I was being gentle and I rounded up, but only 10.8% of foster youth end up completing a 2 or 4-year degree by age 23. And that is significantly lower than the general population. By that age, about 35% of the general population has received a 2 or 4-year degree. So there's a major discrepancy between the percentage of youth and the number of youth who want to go to college and those who are actually able to successfully complete a degree. And there's a lot of factors that weigh into that, which I'm going to talk about as well. One of the key indicators as to whether or not a student persists and successfully matriculates into higher education is financial aid. So research shows that high school seniors who complete their FAFSA application are 63% more likely to enroll in higher education. Also, the more money they get, the higher the likelihood that they will successfully transfer or graduate. And so you can see from the data here that students who received $1,000 to $2,500, only 17% transferred or graduated. But for students who received $7,500, 49% ended up transferring or graduating. And so financial aid continues to be the most valuable resource when it comes to successfully completing a post-secondary program. And the last thing I wanted to mention is that you all really do make a difference. And I don't know if anyone has seen this in some of the recent Chapin Hall reports, but foster youth who were in extended foster care in California who reported receiving a lot of encouragement to continue their education beyond high school had a significantly greater likelihood of actually completing college. And this encouragement came from you all. It came from social workers. It came from the child welfare professionals in their lives who were providing them with guidance and support. So it really does make a difference when you have conversations around post-secondary options, around career aspirations and educational aspirations, and you provide support when accessing resources like financial aid and on-campus support programs. So keep that in mind. Now I'm going to get into some of the changes, legislative changes. And so for folks who are not familiar, back in January of 2018, Senate Bill 12 went into effect, and it requires social workers to assist foster youth with identifying a support person, a designated support person or people, it can be more than one person, who will assist that foster youth with completing college applications and financial aid applications. And this information has to be included in the foster youth's case plan. I'll include the ACL as well as some resources in the chat in just a moment. It also requires social workers to document in the case plan if the minor or non-minor dependent does not want to pursue post-secondary education. So this all has to be included, typically it's included in the collateral section of CWS CMS. I'll include that information as well. But what I really wanted to share today is that AB 153, which was passed last year, correct me if I'm wrong, Simone, requires the courts now to make a finding that supports implementation of SB 12. So they have to, it's included in court reports now. Judges have to review and make sure that a post-secondary support person was identified in foster youth's case plans if they're 16 or older. We also worked very closely to update the TOPE form. So this information is now not only included in CWS CMS, it's also included on that transition to independent living plan. And it's part of the template issued by CDSS. Next slide, please. I wanted to also share some quick updates around K through 12 education and college preparation supports. As you probably all know at this point, AB 1055 modified the definition of foster youth to include youth that are in voluntary placement agreements. So they are now included in local controlled funding formula, LCFF, and they're also eligible for services from foster youth services coordinating programs. I'm going to go ahead and just drop in my favorite resource on this topic, which I'm imagining many of you have seen, but this is the foster youth definitions table from the California Department of Education that kind of explains if a youth is in family maintenance, what do they qualify for? If they're non-minor dependent, what do they qualify for? This table has also now been expanded to include those voluntary placement agreement youth. The other big change is SB 860. This changed the requirements for our foster youth services coordinating programs and our foster youth liaisons to also include the responsibility of coordinating the completion of the FAFSA or CADA application for foster youth in 12th grade. As many of you probably know, I recognize some of your names, so I'm sure you're familiar, but for the past 7 years, we've been running a foster youth FAFSA CADA challenge. We worked very closely with foster youth support or foster youth services coordinating programs and foster youth liaisons to ensure that 12th graders in foster care complete their financial aid applications. And since the start of this challenge, we've seen a 20% increase in financial aid application completion. In fact, in 2 years, we actually saw foster youth high school seniors complete financial aid applications at a rate higher than to the general high school senior population. So it's been a huge success, and SB 860 really helps codify that as one of the responsibilities of FYSCPs. I'm going to now talk a little bit about some really exciting news. So I could sit here and I could say, oh yeah, Senate Bill 154, it did this, this, and this, right? But what this really did, and this is something I want to shout from the rooftop, is this really created permanent foster youth support programs at all of our public post-secondary institutions. So now any foster youth, I know, I see Simone, you did the clap. I should have maybe sang a song or done a dance because I really want to scream this from the rooftop. This was such a monumental accomplishment. Now every single public post-secondary institution, so our UCs, our CSUs, and our California community colleges have foster youth support programs on campus. And this is huge in closing that gap between the number of foster youth who want to go to college and those who ultimately are able to earn a degree. And so this is an amazing, amazing step forward. It also expanded the Next Step program for some of you who work with foster youth who are attending community college. That Next Step historically was not available at every campus. It now is. So a great bill, great, I think it's a really strong indication of our forward progress in this regard. I also want to share too, that in addition, and this is on the next slide, in addition to expanding these programs to all of our public post-secondary institutions, we also made a lot of little tiny adjustments to eligibility for Next Step. So Senate Bill 512 extended enrollment priority and eligibility for Next Step programs to foster youth who were in care on or after their 13th birthday. So previously it was for those who were 16 or older, now it is 13. It also got rid of the enrollment requirement. We saw that there were a lot of foster youth who weren't able to take advantage of Next Step services and supports because they weren't enrolled in enough units. So that has been removed. And then we worked to include some further language that foster youth who enroll in Next Step before their 26th birthday can now stay in the program. And so instead of we kind of tweaked an age cap. So if they were in, it was before it was like if they were in, foster care after 16 and they have to be younger than 26, we changed the law just a little bit to say, well, as long as they get into Next Step before 26, they can stay in until they finish their degree. So making a lot of changes just to make sure that as many former foster youth and current foster youth as possible can access these on-campus resources and supports, because we know they make a huge difference. One thing I wanted to talk a little bit about, and this goes back to financial aid, and this is causing a real headache for a lot of people right now, is that there is a federal bill. It was called the FAFSA Simplification Act. So this is something that's happening in all of our states right now, not just here in California. But as a result of the FAFSA Simplification Act, the FAFSA application that typically comes out in December or October, which would have come out this past October 1st, is now delayed until December. So it has not yet been released. It possibly might not even be released till January. It seems as if the Department of Education and federal student aid continue to change their minds. To get these applications who intend to go to college next year. So this is for the application, the 24-25 FAFSA application. They will have to get that application done as soon as that application is released in December or January. We're monitoring constantly. But again, they have lost months of opportunity to get the application done because of the delay. The good news is that going forward, this bill is actually going to be incredibly helpful for foster youth. One of the major provisions in this bill is that foster youth who are in a higher education program do not need to re-verify their foster care status every year. So they will have to verify once. That can be through the data match between the California Student Aid Commission and CDSS. That's an acceptable form of verification. It can also be now the same old dependency letters that they get from their county child welfare agency or the foster care and buds person, but it can also be a letter from a CASA. It can be a letter from a social worker. They have expanded under the FAFSA Simplification Act, all of the entities who can provide these verification letters for the purposes of financial aid. So that's something to be aware of. Other good news, we now have a Foster Youth Cal Grant Access Award. This is $6,000 per year for foster youth who are attending our public post-secondary institutions. And this is funding that's really intended to be used for non-tuition related costs. So again, this will help them address any housing concerns, transportation, childcare, etc. We also have another bill, SB 150, that went into effect that really aims to help ensure that students who our foster youth and are receiving financial aid can keep that financial aid. So what SB 150 does is really kind of delinks our state Chafee grant from satisfactory academic progress requirements that impact our Cal Grant funding. And this was something that we were able to do because the Chafee grant is Health and Human Services money. It is not federal financial aid dollars. And so it's often treated as a form of federal or state financial aid. But since it's very distinct from that, we were able to kind of delink it from these requirements. One other thing I want to mention, and this is really huge for those of you who have students or work with foster youth who are in college, we just found out that part of the FAFSA Simplification Act explicitly delinks the Chafee grant from cost of attendance and students' financial aid awards. And so if you've ever come across a situation with a foster youth where they're receiving too much aid and they don't have enough unmet need, and they're turning away aid, and this does happen at our CSUs and our UCs, the Chafee grant will no longer be packaged as a form of financial aid. It will no longer count against their cost of attendance. They can receive it in full separately, and it never has to touch their financial aid package or their financial aid award, which I think is major progress, because I was one of those foster youth who had to turn away thousands of dollars in Chafee funding and still couldn't make ends meet because the cost of attendance at my school was just not an accurate representation of what it actually cost to go to college. So this is really, really great forward progress. And then the next thing I wanted to talk about is our efforts this past year to expand financial aid for foster youth. And what I want to say kind of out the gate is that unfortunately there was some media coverage of this initiative that I think incorrectly or inappropriately represented this as free college for foster youth. So if you've heard that, I'm going to add a couple caveats so we don't say that to foster youth and maybe inadvertently get their hopes up and then they still have a bill. And so what this bill did was it expanded financial aid for foster youth using two of our state financial aid programs, the first being the Student Success Completion Grant. So this is really intended for community college students. So foster youth who are attending community college and were in care after their 13th birthday and they're enrolled in 12 or more units will be able to receive $5,250 per semester. Right? I saw some of those faces like, yeah, that's pretty helpful, right? That's a pretty good amount of money. And then the second financial aid program that we've expanded to benefit foster youth is called the Middle Class Scholarship Program. And so for foster youth, this will cover 100% of any remaining unmet need that they have at a UC or a CSU. The only caveat to this is that the foster youth first has to meet a self-help contribution of $7,898. And so that's why I don't want to call it free college, because there's a self-help contribution. It's $7,898. The good news, though, is that any sort of emergency aid that students receive from their Next Step program or their Guardian Scholars program, any sort of, even I think now the Chafee grant will count against this and will bring that amount down. So then the middle class scholarship kicks in. This is something we're going to be looking at addressing legislatively this upcoming year too, getting rid of that self-help requirement. And then the last thing I'll talk about too, we've talked a lot about getting foster youth their financial aid, really maximizing it. We have that Cal Grant Access Award. We now have the Middle Class Scholarship, the Student Success Completion Grant, all of that. But the reality is that many foster youth, nearly 1 in 3 foster youth, end up losing their access to this aid after they enroll and matriculate into higher education. And that is due in part to satisfactory academic progress requirements. So all students who receive financial aid, both state and federal funded financial aid, have to meet these SAP standards in order to remain eligible. It typically requires a 2.0 GPA, and it also requires that they complete 67% of the courses that they attempt. And so what this bill will do is not only benefit foster youth, it'll benefit a lot of lower income and minoritized student populations by requiring campuses to go into to adhere to the minimum standards set in regulation. So they won't be able to impose standards that are stricter. They also have to communicate the standards to the students, and they have to create pathways for students to appeal their SAP standing and their financial aid ineligibility so that they can regain their financial aid. So this is helping to ensure that all that financial aid we've been advocating that they get, that they are able to keep until they earn their degree. Last thing I'll mention is that we have 2 updated education planning guides on our website. One is for adult supporters of foster youth students, and the other is really more geared towards the students themselves. It's for 9th and 11th grade students in foster care. And it includes a lot of what we talked about today in terms of financial aid and all of the grant funding available to youth on campuses or interested in attending a public post-secondary institution in California. It also includes really critical information on the college application process. So those are there and free for you to use. And that is it for me. I'm going to try to stop talking because we have 6 minutes. I'm sorry.
We're going to have to skip some stuff. We do want to take your questions. Also, we will stay a little bit past 12, past the recording to answer some live questions. I previewed this in the chat, but yes, Susan, there is some new guidance around Social Security screening and assistance for youth. Social workers have always been responsible for screening youth for SSI eligibility and for helping them to apply. The age at which they should start doing that has been pushed back a little bit earlier to starting at age 16. We know this process takes a while, and we now have increased responsibilities to ensure that the caseworker not only helps them with submitting that application, but also with filing a request for reconsideration and subsequent appeals if that initial application is denied. And if needed, they should also help to identify an appropriate representative payee if needed. Most social workers do not know how to do this, so there is some funding attached to this to try to help counties support perhaps an eligibility worker or someone who really takes on that role of helping with SSI application for all eligible folks within the county system. Hopefully you have that available. If not, partnering with an SSI attorney is likely the most effective way to move through this process. I'm going to skip information on foster youth rights in the interest of time, but what's important to call out, recent legislation signed into law last year, effective this year, is that the Foster Youth Bill of Rights should be provided to the youth in their primary language, as well as their court report, case plan, and transitional independent living plan, their TILP. So if you have a non-English speaking youth, please make sure that that is being appropriately translated. So,
great. So shifting gears a little bit, we talk about taxes. I know we were already doing some chatting in the chat, and what we were chatting about is probably the most complicated situation. So don't feel like, oh, taxes is just complicated. Not everything about taxes is complicated. We started doing work on taxes a few years ago when some eligibility changed for some other tax credits, and then we ended up proposing a tax credit specifically for foster youth. If you think about it, this is sort of, I don't want to like poo-poo guaranteed income, but this is better than guaranteed income. It doesn't affect your benefits. This is the existing tax system, existing money that's, you know, on the table. It's how it's a way of redistributing wealth to people in our country, and we shouldn't just be tapping into it for rich people, right? We should be tapping into it for everyone. And so that's why there's tax credits based on sometimes income. So the California Foster Youth Tax Credit was launched, just first available in 2023, this tax season, earlier this year, and it was funded with $21 million annually. We've spent in this first year about a little more than $5 million. So it's early stages of implementation, right? And we want to see all that money get into young people's pockets. So we got to keep getting the word out about this. It provides about $1,000. I say about because this year it provides next tax season, 2024, it'll provide 1,117. It increases a little bit each year. It's a cash back and refundable tax credit. And it's for youth who file a state tax return and were 18 to 25, not yet 26, on the last day of the tax year. So for next tax season, it'll be for 2023. They were in foster care on or after their 13th birthday, so it's aligned with Next Up eligibility. And they earned at least $1 during the tax year. So in this case, this year for when they file next year, and not more than about $30,000. Again, it changes a little bit each year. This coming year, it'll be $30,931 is the threshold. They have to have lived in California for at least half the tax year as well. They receive the full 1,117 if they make up to 25,000. After that, it starts to taper off. Once you hit that 30,931, you're at zero. So that's how the eligibility works. Youth do not have to provide a verification letter like we're used to, right? But there's an option for them to upload it to their state tax return to be extra careful. There's a back-end verification that'll happen. It's gone really smoothly so far. And they just have to check the box saying that they allow for the verification. It has, again, no effect on public benefits. So this is another $1,000+ that could be in young people's pockets. There's a youth outreach flyer that we have that's on the screen there. Feel free to, please, not feel free, please do circulate this widely to young people. And you have to have a social security number or an individual tax identification number if you're undocumented, to file and get this. And you can't claim it if you're claimed on someone else's tax return. So you also want to make sure for young people that are still connected with like resource families or whatnot, that they're clear on, it's like, are they receiving more than half their support from that family? If not, they shouldn't be being claimed. They shouldn't be considered a dependent of someone else. So have those conversations. We have a lot of resources to help people assist young people, and we're happy to field questions about that. I'm going to skip the next slide. It just talks about the progress we saw in year one, and people can look back at it if they're interested.